That's right, folks. Everyone's favorite villain is back and snifflier than ever. Hank Breenan made quite the ruckus on the Twitter X's earlier today after filing a motion withdrawing as special prosecutor from the Karen Reed case.
Huh?
Hello, and welcome back, roommates, to another titillating edition of Alexasrewm, where we are not lawyers, we are not medical professionals, and we are not law enforcement. We are just people. People who have opinions about all things going on post-Karen Reed verdict, including Hank Breenan withdrawing from his position of special prosecutor in the Karen Reed case 30 plus days after the fact. Guess that means the check cleared. Shout out to @SuspiciousSauce on the Twitter X's for sharing this. Motion to withdraw. Penny Paralegal used talk to text to draft up every single one of these. That or she must really hate Hank Breenan. Undersigned counsel moves to withdraw from the above docketed matter. Undersigned counsel's position as special prosecutor has concluded. Short, sweet, succinct, to the point. Dated today, 7/30/25. Respectfully submitted, yours truly, Hank Breenan. I guess this is what the walk of shame looks like, folks. You win some, you lose some. Seriously, though, what was the point of him filing this 30 plus days after the fact? Buyer's remorse? Did the check finally clear? When was the actual end date of your contract and when your duties had officially concluded? Because that might be useful information to, I don't know, provide an emotion. So you have that memorialized? I'm just saying. That said, at the very least, Mr. Hematoba gave the people what they wanted, with one little last spelling mistake, before he sniffles his way back into whatever finger painting class Morrissey picked him up from. Now, there has been a flurry of motions, actually, that were filed today, aside from the one filed by Mr. Hematoba, including this motion that was filed on behalf of Karen Reed, seeking the unimpoundment of all sidebars, which we have all been dying to read. And when the hounds are released, you bet your bottom dollar, kids, it is going to be like 101 Dalmatians up in this mother ducker. Sorry. Maybe this is why he wanted to withdraw. Because he's afraid of what's going to come out when they do, in fact, go to quote the great Nurse Kim, unimpound town. Either that or he's just found out he's been cast as an extra in the next Dunkin' Donuts ad for their newest refresher flavor, Golden Shower. Defendant Karen Reed's motion for relief from April 14th, 2024 order to impound sidebar conferences. Background. On April 10th, 2024, the Commonwealth filed its motion in limine for appointment of court stenographer, ongoing order to impound all sidebar conferences and impoundment of juror names during trial, attached hereto as Exhibit 1. Commonwealth sought impoundment of the names of all jurors, all sidebar discussions, including sidebar discussions during pretrial proceedings, and that sidebar discussions and juror names be unavailable until a verdict is returned. Here we are today. A verdict has been returned. She has been acquitted. She is free. Now we just need to free her Lexus. The Commonwealth's rationale was that the publication of matters discussed at sidebar, including juror names, information, and potentially sensitive responses to inquiry while trial is ongoing, could prejudice the parties and expose jurors to extraneous matters. Now, since then, we know a number of the jurors have come forward utilizing their names as well too in some of their media interviews, Paula Prado, for example, juror number, I think she was juror 11. In its motion, the Commonwealth noted that after a verdict is returned, the potential prejudice to the parties will be greatly lessened, and that all parts of the record, except any that the court specifically finds subject to further impoundment for good cause, would then be made available to the public. Yeah, so you said, hey, really, you said you were going to release the hounds. You said you were cool with it. Here we are, back to school shopping. I got my spiral notebook, a little construction box with the clasp at the end, my Powerpuff Girls lunchbox. I got it all. Got it all, but I want the sidebar. You got to give me some sidebar. Legal standard. Rule 7 of the Uniform Rules of Impoundment provides that a judge evaluating a motion to impound documents may enter an order of impoundment only if good cause to withhold documents from the public is shown. Yeah, I don't think a legal ground would be, oh, this is too embarrassing for the DA's office or for the Massachusetts State Police. Like, no, it's called transparency. You know, we give a little, you give a little, right? To determine whether good cause is shown, a judge must balance the rights of the parties based on the particular facts of each case. Some case law there. Decision to grant access to court documents is best left to the sound discretion of the trial court. And good news is I think this is being presented in front of a different judge because Beverly has packed her bags and gone over to Plymouth. So I think this will be heard or decided through a different honorable judge, to be exercised in light of the relevant facts and circumstances of the particular case. Yada, 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 citing uniform rules on impoundment procedure. In making the good cause determination, a judge must balance the interest of publicity and a defendant's right to a fair trial. If there is good cause to impound documents, a judge is required to tailor the scope of the impoundment order so that it does not exceed the need for impoundment. I mean, it's interesting because you have the defendant here asking, release it all, right? It can only be helpful, I'm certain, of any potential lawsuits or the current civil case that she's facing as well. Once entered, an impoundment order remains an interlocutory order subject to the continued existence of good cause. Yada, yada, yada. Unlike other orders and judgments, an impoundment order carries no continuing presumption of validity to sustain it against a proper challenge subsequently brought. A party seeking the release of impounded court records does not bear the burden of demonstrating either that there has been a material change in circumstances or that whatever good cause may once have justified their impoundment no longer exists. So whatever you wanted to keep secret at the time, you wanted to go to sidebar, you didn't want to expose on national television in front of millions and millions of people, whatever the reasons were, now, unless there's a justifiable reason, like say, I don't know, there's a duty to keep some of this stuff impounded because of what might be ongoing federally, who knows, what if anything, the burden of demonstrating the existence of good cause always remains with the party urging their continued impoundment. I mean, how many times can we say the word impound? A proper challenge to the continued validity of an impoundment order is raised every time you see the word impoundment, or impound, or some variation of it. Take a sip. Is raised whenever the party seeking to modify the order comes forward with a non-frivolous reason to do so. Once such a reason is before the court, the obligation of the motion judge is to apply the same balancing test used in determining whether to grant an impoundment order in the first instance. Argument. So this is the juice. This is the good stuff. 1. Because good cause no longer exists for the order of impoundment to be continued with respect to the sidebar conferences, and because access to those materials is required for trial preparation, the impounded materials should be released at a minimum to the parties, right? So they don't even have access to this stuff. So again, if she wants to prep for any future cases that she might have, this might be useful information for her to look back on, right? See what they discuss, see what they could potentially use in this civil case, because as we know, it's more open season in civil court than it is in criminal court. The order of impoundment related to the sidebar conferences was entered by agreement on April 14th, 2024. On November 13th, 2024, the court further ordered that certain transcripts of sidebar conferences be provided to counsel and the court. See Exhibit 2. The court issued a separate order of impoundment of the list of jurors for the second trial on June 18th, 2025, and extended that order on the 26th of June. See Exhibit 3. Order to extend June 18th, 2025 impoundment order. In accordance with these orders, the identities of the deliberating jurors in both trials in this matter remain impounded, right? And I don't think anybody really has a problem with that so much. The aspect of the Commonwealth's April 10th, 2024 motion remains unchallenged here, as the issue of juror identities was subsequently addressed by the court. Ms. Reed instead seeks only the release of the sidebar discussions that took place during trial and those that addressed evidentiary rulings prior to trial, because the good cause the court recognized when impounding such conversations no longer exists now that a verdict has been rendered. This is like her one big FU to Beverly canola oil, right? Bring out the dancing lobsters. Commonwealth was concerned that the release of sidebar conference transcripts during the pendency of the first or presumably second trial could expose jurors to extraneous matters. However, now that the trial has concluded, that issue is moot, right? No jury trial, no problem. 1. As the Commonwealth noted in its motion, after a verdict is returned, the potential prejudice to the parties will be greatly lessened, and that all parts of the record, except any that the court specifically finds subject to further impoundment, keep forgetting to take a sip, for good cause, would then be made available to the public. The court has found that the identities of the jurors should remain impounded until and unless otherwise ordered by the court. With regard to sidebar conversations, however, good cause no longer exists for impoundment. Such discussions should now be part of the public record. I mean, they just released all the Richard Allen transcripts, so why not, right? In balancing the public's right to inspect documents against a defendant's rights guaranteed by the Sixth Amendment to a fair trial, a court may consider a variety of factors. These may include whether the information has already been disclosed, the nature of the documents under impoundment, or whether there are alternatives to withholding public access, such as a change of venue, which there was none. There are, at this juncture, a few aspects of this case that have not been explored in depth publicly. In fact, it's in its determination to continue the order of impoundment regarding juror identities, the court noted that this case has garnered significant and divisive attention in Massachusetts and across the nation. Framing a factually innocent woman will do that. In other words, virtually every issue in this case, especially following a completed trial, has already been disclosed. This factor weighs in favor of ending the previous order of impoundment. Another factor, the nature of the documents under impoundment, also weighs in favor of their disclosure. As noted, Ms. Reed herein seeks only release of sidebar conferences, not the identities of the jurors. Just to be clear, in case you missed that the first 47 times we said that, we don't care about that. We don't need to put them on blast. We just want the goods. Give us the goods. Give us the meats. To the extent deliberating jurors could have been exposed to the extraneous information, blah, 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 blah. Additionally, there are a few, if any, privacy interests implicated by evidentiary discussions at sidebar. The extent of the community interest also, such a cliffhanger, weighs in favor of the release of the sidebar conferences from the order of impoundment, even while acknowledging the court's duty to minimize the effects of prejudicial? Well, they are kind of douche canoes, so prejudicial pretrial publicity. Though Miss Reed does not bear the burden of establishing that good cause no longer exists for the order of impoundment, God dang it, to remain in fact and need not establish a material change in circumstances, see yada yada yada, it is apparent that any good cause that did exist during the trial for the order impounding sidebar conversations is no longer present. The factors the court must consider in determining whether to continue its previous order of impoundment. I skipped the gym today, so this is good for, the arms. All instead suggests that the referenced sidebar conferences should now be part of the public record of these proceedings. Conclusion: for these reasons, Ms. Reed respectfully requests that the court release any sidebar conferences that occurred during either of the two trials in this case. Yes. A lot of sidebars. I'm curious if anybody tallied up the first trial and the amount of sidebars for that versus this one. I have a hinting suspicion that there were more in the first one. But I don't know. I don't know. It could be making that up. And any pretrial sidebar conferences dealing with evidentiary issues from its prior order of impoundment, except as the identity of jurors. Ms. Reed also respectfully requests that the court allow this motion administratively without a hearing. Yeah, like, let's stop, having to schlep everybody to frickin' court. Norfolk Superior. Or if we have to do this, we'll do it on a Zoom or something. I mean, it's a waste of time, money, gas. This could just be easily decided while you're, out there on the green, right? Putting, Happy Gilmore 2, whatever golf people do. Yours truly, Karen Reed. So that's why I'm kind of thinking that Hank Breenan's like, yeah, y'all didn't pay me to deal with all of this. So I'm Audi 5000. I will link those both in my show notes below so you can give them all a look-see as well too with your eyeballs. If you enjoy reading along to my narration. I know my voice isn't as smooth and buttery as that of Morgan Freeman's, but I'm working on it, I feel like after a few more sips of water, it is water, I promise, in this glass me and my wife stole from a restaurant that we will never return to ever again, so. Why do you think Hank Breenan filed this motion to remove himself as special prosecutor? Do you think it's just as simple as, hey, the check finally cleared on the last payment, the last installment, you're all caught up now? I've bankrupted your county successfully, so kudos to you, meatball. That's been my last meatball I will ever indulge in again. I want to know your thoughts in the comment section below, because I do try and read them all, even the slightly unhinged ones. I may not respond to every single one, but I definitely do my best to get back or heart as many comments as I see. So let's continue to have these conversations, and until then, hydrate, because water